Yeah. Yeah.
Hello, I'm sitting in the front row, Marty, so no pressure. No heckling.
Well, ladies and gentlemen, my name's Tim O'Callaghan. I'm the Deputy Managing Partner of Piper Alderman, and I welcome you to Piper Alderman for this event, a panel discussion for the Chartered Institute of Arbitrators. And we remember that we're on the traditional lands of the Kaurna people, and we pay our respects to Kaurna elders past, present and emerging. And it falls to me to welcome Geoff Farnsworth, who then will introduce Andrew as moderator here. It's worth noting, though, that Geoff is the, I think, the first, perhaps the only sitting president of Chartered Institute of Arbitrators who has visited South Australia to participate in one of these events. So we really do appreciate you doing that, Geoff. And wanted to welcome His Honour Patrick O'Sullivan, Justice Patrick O'Sullivan, to the panel, and Marty Conduit and Geoff. And I'll pass you on to Geoff now.
Thank you, Tim. Thank you, everyone, for coming along this evening. Thank you for joining us on the panel. I really just wanted to thank Piper Alderman very much for hosting this event tonight. The work of Ciarb is nothing without the support of firms and professionals such as Piper Alderman. So we're very grateful that you've provided this platform. Yes, it may well be that I am the first Ciarb president to come to Adelaide, which is an indictment. I think in many respects, at least, well, here I am. The reason for being here, well, I might just pass to Andrew. I think that's probably the best thing to do. Well, you can warm us up.
Okay, well, I'll perhaps introduce the format and what we're going to try and attempt to do this evening and hopefully achieve, which is, it is intended that this evening is a discussion, and it is a discussion involving different people and different perspectives. But a bit like arbitration itself, the procedure will be flexible and will be adopted as the requirements require. I will attempt to try and just facilitate a discussion between people, and so that in doing so, I can hopefully draw out some issues about arbitration and what we're here about. In order to do that, we've got an excellent panel of perspectives, an excellent panel of backgrounds in terms of people up here. Now, immediately to my left, we've got Honourable Justice Patrick O'Sullivan of the Federal Court of Australia. I don't think anyone in this room won't know who he is and his background, but that obviously enables us to have a judicial perspective in terms of the discussion we're going to have tonight. And then sitting next to His Honour is Geoff Farnsworth, who's, we've noted, the President of the Chartered Institute of Arbitrators. As well as being a practising lawyer himself, he also represents the Chartered Institute tonight, and one of the things we might discuss a little bit is about the theme of what we're talking about tonight, which is 30 years of the Chartered Institute within Australia, which is giving us this opportunity to have this reflection and this discussion. And then furthest from me is Marty Conduit, who is a barrister at Edmund Barton Chambers, who practices principally in construction activities, but has also been involved in relation to arbitration matters and disputes that are resolved through arbitration. And so we're hopefully bringing through different perspectives and different ways in which we can look at arbitration and hopefully draw out, as I say, the flexibility of the process and what it really involves. So in order to get us started, I thought I might start with the topic, as I say, as to why we're here today and why we decided to do this talk. And that is because it's been 30 years since the Chartered Institute of Arbitrators came into Australia. For those that don't know, the Chartered Institute itself is a London-based organisation, and it was formed in 1915. And so it spent a lot of its life before it came to Australia, overseas, but it has really prospered in Australia in the last 30 years. So I thought we might have a discussion about why is the Chartered Institute and what it represents and what it provides relevant to Australia, and how has it found a role and place in our community, and perhaps a little bit more about that role. And that probably is best suited for me to ask Geoff to say a few words about that to start with.
How long have we got? Andrew? Look, thank you for that opening question. The Chartered Institute was formed, as Andrew says, in 1915 as an attempt to provide a professional qualification for arbitrators. The designation of Fellow of the Chartered FCIRB is, so far as I'm aware, the only designation of professional recognition of arbitrators who have completed a course of training and have, as a result of that, achieved the designation of fellowship, which also requires adherence to a rigorous professional code of conduct. What all that means, I think, sort of feeds into a question about, perhaps why is an arbitration as well established in Australia as it is in other places. And I like to think that part of the work of the Chartered Institute is to provide a certain consistency in product. So I would like to think that if you appoint a Fellow of the Chartered Institute as your arbitrator, he or she has been appropriately trained, they know how to write an award, they know how to conduct a hearing, they understand the law, they understand the jurisdictional issues that may come up in a dispute. So I think what we're at that level, we're a bit like the Guild, we're the Guild for arbitrators. What we also want to do, which I think is a very important part of our mission, is to promote arbitration more generally and raise awareness of arbitration as a form of dispute resolution. This is part of a very long conversation, and we can talk about things like, there's many different shades of arbitration, everything from, multi-billion-dollar international construction arbitration over nuclear power stations in somewhere or other, down to more prosaic forms of arbitration. But it's all arbitration in my view. And so one of the things that we're doing, we had a chat before the panel commenced, and we may talk a bit more about this, is the use of arbitration as an adjunct to litigation process. Sorry, I'm straying a little bit off script, but it's just an example of, so we are engaging with courts and judges around the country and the professions to raise awareness of the powers that courts and judges have to refer matters out to arbitration in inappropriate cases. Again, I could talk about this for a long, long time, but I might leave it at that unless you'd like me to keep going on. You've probably got questions for other panelists.
Well, does anyone else want to make any other comment at this stage? Nope. I might move on though. Well, in the last 30 years since the Chartered Institute has arrived in Australia, there has been some significant changes in Australian arbitral law and Australian arbitral practice. While arbitration might itself be a very storied process, the Commonwealth Act has only been around for 50 years, but the model law having force of law has only been around since 1989. And up until 2008, all the state courts and the South Australian jurisdiction specifically did have common form arbitration acts, but they were different in terms of the processes and the models that they used compared with the Commonwealth Acts. So in the last 10 or 15 years, we've seen some significant differences, therefore, in arbitration from what has gone before, with the adoption of the model law across Australia at both the federal level and at the state acts. I wondered, does anyone want to comment on how much these changes have had an impact on arbitral practice in Australia in the last 15 years or so, and reflect on how they might see us going forward?
I'm happy to
Get on.
start off at two. World's best practice, really. I mean, I think we now sit with Singapore as the adopters of the UNSTRAL model law. It promotes finality. I mean, I don't need to recite all the benefits of the model law to you all here, or maybe some of the younger lawyers haven't.
There are a few younger lawyers, and so perhaps some explanation about what the model law is and why it's important.
The model law is as I say, I guess considered best practice in international arbitration practice and procedure and law. It promotes, well, if you look at the domestic legislation, it promotes the fast, final, informal resolution of commercial disputes. The primary object of the Arbitration Act is something that I often find myself reciting in awards that I write, just to make that point, that the arbitration process is not meant to be technical and formal. It is meant to be an informal, fast and final resolution of commercial disputes. So I think given that arbitrators are now practicing with that as the legislative underpinning, the mandatory stay of court proceedings that are commenced in default of an arbitration agreement is another regularly exercised power that the courts are called upon to use in support of arbitration, to make it very, very clear that the courts have that supportive role in relation to arbitration. But I'll stop there and let others.
Marty, perhaps from your perspective, how does it impact upon the practice as counsel in arbitrations that the legislation is now consistent across state and federal and has reference to international practices as well?
Well, I'm glad that you refined the question to the last 15 years rather than the last 50 years, because I was going to struggle there. But certainly in the last 15 to 20 years, I can say in the area that I practice in, which I know a lot of people here do, which is construction law, that arbitration, particularly for tier ones on large infrastructure projects, is considered the forum of choice. And I think where you have projects which involve parties from all over Australia, quite often when you have large projects such as, say, when there was the GLNG works being undertaken in Queensland, and there was certainly a shortage of labour, and you had a lot of subcontractors on fly-in, fly-out arrangements, as we also with INPEX and other large projects. It means that arbitration is accessible because at a domestic level, there's consistency in all the laws and it's easily understood and applied by the parties. So I think anecdotally from what I saw, particularly post-2008, there was a real adoption of arbitration as the preferred method of dispute resolution. And I think perhaps the peak number of arbitrations that I've been involved with would have been in around probably 2015 to 2020, which was post-GFC, when there was a lot of dispute work happening. So I can say that those legislative changes really did have an impact. I'm not certain that the growth in arbitration is continuing as it did perhaps a decade ago, and I think there's perhaps reasons for that. And I think, you know, there are things like Tesseract, which caused a little bit of uncertainty around application of proportionate liability legislation, and also just lawyers getting control of the process and causing it to run like ordinary litigation. But I do think that there are real benefits to arbitration if it is applied in the correct way. And I think that the legislative change had a real impact, particularly at that point in time. And I think there's prospect for it to sort of get back on the rails.
Perhaps I could ask from your perspective, especially there was a comment there about the way in which lawyers have perhaps approached the process. I don't know whether or not you wanted to comment on any of that.
I think that Marty was right when she said that it's about certainty. I mean, you're dealing with a well-established set of rules, and if you're dealing with either interstate or or international arbitrations, then you've got some idea of what it is that you're dealing with, and it's the fear of the unknown. Parties don't like the unknown, and this gives some certainty. That's what it is.
I suppose that leads into the next topic I wanted to move to, which was that as part of those changes in 2008, there also have been greater recognition in terms of the role of arbitration in some courts. Yourself, Your Honour, you sit as the Specialist Justice or the Arbitrationist Judge in South Australia in relation to commercial arbitration, which is something the federal court recognises. It has practice notes. It has materials on its website directly in relation to that. Has there been a change, or what is the role of the Australian courts with respect to arbitration, as reflected in the discussion we've had so far? Is that something that you would like to comment on?
I think it's very much the judge in question. There are some judges who frankly don't know a lot about arbitration, and there are some who are more knowledgeable about it. And you'll get, I think, understandably, a bit of a reluctance if it goes to some judges who don't really understand the process, and because they may never have practiced in it, or they might just not know about it. Whereas those judges who have practiced in the area or have had some idea of it as a judge, I think are probably far more amenable to dealing with perhaps referring parts of matters out to arbitration. Although I haven't seen Justice Stewart do that, but his background, or Justice Sarah Derrington, but their background in Admiralty or Maritime would certainly probably influence them, given it's such a major source of arbitration.
One of the changes that was introduced by the movement from the old state acts to the new state acts based upon the model law was the lack of discretion in relation to the referral out. Has that made an impact upon the court's attitude towards arbitration or the parties' attitude to arbitration, do you think?
No, I don't think so.
You mentioned that as well. Is that something that you think is of any significance?
Okay, a couple of things. We've talked about, I guess, arbitration practitioners like talking about arbitration. And one of the things they bemoan is the fact that there's not more of it. And you've got to ask yourself, well, why is that? Why aren't, and one of the hypotheticals I sometimes throw around is, well, if arbitration is so good, why do you need an arbitration agreement? Why don't parties go, yeah, we can either go to the court or we could refer it to arbitration. Why don't we just take it to arbitration? Because we all know that's fast and final, and and informal and all that sort of stuff. What I think has changed from my perspective is courts are probably more expensive than they used to be, just in terms of filing fees and setting down fees, hearing fees. So there's that, which is a factor. I mean, an arbitrator can do a lot of work for $20,000, which is basically what you're going to be spending on court fees if you go off to court. So I think that's something that people need to think about. It's much more productive, I think. So there are real productivity benefits to arbitration, because you don't need just the way that the pleadings or the memorials or the submissions are put together is not as formal. You cut to the chase, I think, more quickly in arbitration than sometimes you can when you're involved in litigation. But once you go through the door and you're involved in litigation, I just don't think a lot of people think about the fact that having gone through the door of the court, we could actually then send it out to arbitration. I just don't think they're aware of it. It's not a common practice. And again, we were talking about it just before the session began, and His Honour was sort of saying that you will refer things out to assessors or appropriate matters. But I don't think a lot of judges. And you mentioned the Admiralty Court. We don't look at Ian. Ian's a distinguished Admiralty lawyer too, but we've never really done that, have we? We've never sort of approached the court to say, could you please send this out to arbitration? I don't know why, but it's certainly an option.
Depending on what it is.
Yeah, depending on the nature of the case. There, as we were saying before, that there are some matters that you wouldn't send to arbitration. You just wouldn't. You wouldn't send them there because they're not appropriate to be dealt with by arbitrators. There are plenty of matters that are contractual disputes. I mean, 9 contractual disputes out of 10, I would have thought, could be dealt with by an arbitrator, both in terms of liability and damages. plenty of other things, don't even think about it. But those sorts of disputes, why wouldn't you send them to an arbitrator? And why couldn't a member of the bar deal with a relatively straightforward, or not even a straightforward, reasonably complicated contractual dispute? What you do on a daily basis as an advocate. So do you think I seem to think it's reasonably easy to sort of swap from, take your advocate hat on, put your arbitrator hat on, but maybe others don't find it so.
I think that the reluctance to do that on questions of law is the absence of a right of appeal. And that's really the big thing, I think. And that's both, it's a two-edged sword for arbitration.
Of course.
One of its benefits is that it's final. One of its
disadvantages is it's final.
Is that it's final. I think that's probably what it is.
Yeah.
And so if you're talking about pure questions of law, which normally carry with it some sort of damages component, that's a different question. But the pure questions of law, people can be reluctant, I think parties will be reluctant to go to arbitration just on that, but there's no reason why you can't have a question of law if there's a complex exercise to be carried out, say an account, why that couldn't go to an arbitrator.
It does come down to having the right arbitrator at the end of the day, I think. And I know Nick and I were involved in a matter where precisely that problem occurred, where we didn't have the right arbitrator, which was not a fault of ours.
Not a Ciarb fellow.
No, definitely not. And they were questions of law that the arbitrator didn't have the experience to answer. And so, it was just the wrong person for the job.
Well, it's interesting you say that. I mean, a long time ago, I was working in London and at Keating Chambers, at Donald Keating Chambers, and one of the silks there was saying that the senior bar and a lot of the construction juniors were getting pretty jack of some of the decisions that were coming down from arbitrators, and they were there moving away from it. So it's very sensitive to that. You get a bad result from an arbitrator that you think that's wrong, and you either don't go to arbitration or you certainly don't go to that arbitrator again. And so there's that.
Yeah, and it's problematic because you can give the client all the advice in the world, but when you have a decision which is just inexplicable, what do you do?
Well, that's why training's important.
And we had a right to appeal because that was under the old Referrals Act, or we tried to anyway.
Yeah,
There's kind of a right of appeal still, but you've got to opt into it.
That was the other problem.
we had a strange contract, and we did get some judicial assistance initially, but then we didn't.
Rubbed out.
Exactly.
Brief was fine when it left my hands.
Perhaps then we could look at it from the other perspective. When you're in arbitration, the role of the court in assisting arbitration and what it does in that regard, because it really is, it's not a competitive relationship, it's a relationship that can work together. And I know, Marty, you were talking about that a little while ago in terms of the ability to go to court and get orders to assist in arbitration.
So I've certainly, obviously, probably in the last 12 months, obviously there's always interim measures. I had one recently where we needed injunctive relief pre-arbitration, and there was a provision in the contract for urgent declaratory relief. The other side tried to say it didn't apply. I think it did, but in any event, we could rely on, I think it's section 17J, and we could get that. There was obviously, as Robbie would be aware, there was plenty of assistance through the NRA arbitration on the question of the parliamentary privilege and public interest immunity, where the state claimed public interest immunity and parliamentary privilege, and there was no jurisdiction, so the parties had to go back to the state courts to get that issue resolved. And so in that respect, certainly the court was not only invaluable but absolutely necessary. And so I think even if you're in an arbitral process, then issue of subpoenas, all of those sort of things, they go hand in hand. So it doesn't mean that you're not having to have regard to the court for those processes.
I mean, the choice of seat is obviously critical in that. And, you may have clients or parties who are uncertain about arbitration, but if they know that the courts of a particular seat who have that supervisory jurisdiction are solid and governed by the Australian model law and legislation such as ours, that must provide some comfort as well. Because even though you can't appeal an award, but there is recourse in appropriate circumstances. If there's misconduct or by the arbitrators.
Yeah, that supervisory role.
Yeah, I think the courts are generally pretty willing to assist. Can't see why they wouldn't.
No.
We're talking about then, for practitioners' perspective, in terms of those people that may be considering being involved more in arbitration. We've talked about some of the key issues that they might need to consider: the ability to write awards, and I think we were talking about earlier, the willingness to actually make a decision. That I find interestingly that sometimes that some junior or new arbitrators seem to have reluctance to engage in. Is there anything in particular that people should be conscious of in terms of why arbitration or how they might be involved in it, in terms of any skill sets that they should be, or is it just making sure that they go to a Chartered Institute course and get themselves properly trained?
Well, I'd come back. Sorry if I can launch him on that. I'd come back to your a couple of things. So you've got young lawyers in your team, and I assume you spend the time to explain to them what arbitration is all about, and most importantly, I think how it differs to litigation. And I think if young lawyers and other practitioners and barristers, the profession is conversant with what's different between arbitration and litigation, that arbitration isn't just litigation by another name. And if you approach it in that way, you're losing pretty much all of the benefit really of arbitration. That's what I would be trying to convey to people, that it's different. It's different to litigation. As you mentioned, it's more flexible. There are things that you can do in arbitration that you can't do in litigation. You can approach an arbitrator or in a way, or a panel in a way that you want to approach a judge. So if practitioners such as you know, you've got those tools in your box. So when a dispute comes along, you can look at it and say, maybe it has to go to arbitration because that's maybe that's what the clause says. But if it does, then there's nothing to be feared. There's nothing. You're not afraid of that. It's like, well, great. Well, this is a good one for arbitration. This is how you do it. You're familiar with the rules of the particular whatever institution is dealing with it, or if it's ad hoc, you've got experience in managing ad hoc arbitration. So just having that familiarity with how the arbitration process works. I mean, it's not as common as it needs to be. And I think we as practitioners, one of the things that we do need to do is take the time to reflect on that. And why is it not better? Why is it not better known? Why are the younger lawyers not gaining that experience so that they do understand that there is a difference? And I think the judge made the comment before the panel that you don't have any of your commercial partners here, do you? The people who draft contracts and make the decisions about putting arbitration agreements in there?
Well, there's not too many, no. Tim, you've probably drafted one or two contracts, but not many.
But that's where it starts, right? I mean, you've got to advise your clients. Well, okay, dispute resolution clauses. Have you thought about it? Do you want to go to arbitration, or do you want the courts of a particular jurisdiction to deal with it? And the advantages and disadvantages, the pros and cons. Here they are. But how many people think long and hard about dispute resolution clauses in contracts?
Yeah, I must admit, I tend to take the arbitration clauses out.
We'll speak afterwards.
They're IP clauses, and so I frankly tend to think that the Australian courts are efficient, so efficient that they're a better alternative than arbitration. So
No. But if I can, did you say they're IP related contracts?
they're IP related contracts.
Well, if you can be confident in getting in front of a judge who understands IP, I can understand that.
Yeah.
But what if they don't?
Well, that is an issue. Anyway,
There, I don't need to put you on the spot.
But as you said, there are certain areas that I take your point. There are certain areas that are ideal for arbitration, and the sort of things you're talking about, I think, are those things that are ideal for arbitration.
Yeah. Well, so one thing we haven't talked about.
So just anyone in the audience, I'll just make sure we do speak up loud enough so that we can be picked up. I'm not sure if I mentioned that before, but they will be recording this. And if you are getting questions from the audience, if anyone wants a microphone, I'll go get a travelling. I'll get a.
Can I say a couple of things just about where I see where arbitration has really worked well and where it's really attractive? I mean, the first one is confidentiality, right? And particularly in the construction sector, the parties like it because they don't want the intricacies of the dispute and a lot of information about how they manage projects and all of those sort of things to be in the public domain. So that's why I think it's particularly attractive in a construction sense. But the other is flexibility. And I've really seen if the parties really engage in adopting a process which works for them, that is where it has its real benefit. And I've seen that certainly in terms of the pre-hearing steps about how that's managed, and also about, there's not the delays in getting access to your arbitrator, which there sometimes is with the court because of the judge's court load. You can actually have hearings convened really quickly and efficiency, and decisions can be made with a lesser level of formality. But in the actual hearing process itself, you can tailor it to the needs of the parties. We had one arbitration which was initially meant to be held between two separate locations, but wasn't in the end because of the arbitrator and his needs. But in terms of saying, okay, well, this is the time we've got allocated, that's the time we'll use. So it's almost like a stop clock arbitration in that sense, which, a court would never do because it would be seen as a lack of procedural fairness. And there are those benefits where obviously courts attempt to hot tub witnesses, but having less formality around getting the experts in together and being able to, sort of limit cross-examinations to topics so that, the parties can get through the evidence much more effectively. If the parties commit to a process to try and not have to draw out the length of cross-examination but stick to the critical issues, arbitration is a really beneficial process in that sense. So that's where I find that it has worked really well on what can otherwise be disputes that would just be perhaps twice the length at hearing.
Throw you onto the spot, then why not expert determination?
Because look, some of the I've actually seen parties have a tendency to turn towards expert determination. Previously, a lot of the work I'm seeing is there's been adoption of the GC21 contract, which is a process which is expert determination, and then if there's a right of appeal if the dispute is worth more than $500,000. The difficulty I'm finding with expert determination, and I've got a matter where it's currently manifesting itself, is that there is no rules, right? It's just what is in the contract. And usually the mechanism for expert determination set out in the contract is very brief, right? So you don't have the model law, you don't have all of that precedent that surrounds it. And so, one of the problems I've got at the moment is a matter that's going to expert determination, which is both for contractual and non-contractual claims. And my client needs discovery, and there's no provision for discovery in the contract. And so we're like, well, what are we going to do? You get to a process where there's no procedural fairness here because we can't get access to the documents that we need to prove the non-contractual claims. So that in itself is problematic. So I think expert determination is great, but very limited to what you actually agree in writing.
Well, there's a whole lot of points that's sort of arisen out of the last 5 minutes. Going back about people who are reluctant to make decisions, so that's a training issue. If they can't make decisions, they shouldn't be practicing as arbitrators. Simple as that. In terms of, it finishes up with Marty's point about expert determination. Dispute resolution clauses are typically not thought about carefully enough, or are discarded, or simply taken from another contract and can be wholly unsuitable, which runs into a whole series of disputes about the clause itself, whether it works, if it is, has there been a dispute arisen underneath it, rather than properly considered, usually cascading. Try this, try this, try this. Or alternatively, up to a certain monetary limit, it's this process. After that, it's a different process. Or alternatively, you're bound up to a certain limit, but not thereafter. None of that is really thought about, at least it wasn't carefully. But the other thing too, I think arbitration has to watch this space very carefully. It's a bit of a victim of its own success in the sense that courts have picked up a lot of processes which were used in arbitration. Witness statements, hot tubs, concise statement. In the federal court, you can get a concise statement, depending on the matter. So there's lots of things that the courts use that have had their genesis in arbitration. If you look typically at what the benefits of arbitration are, you talk about flexibility of procedure. Well, a lot of the courts can be pretty flexible now. You talk about speed. That can be an issue. I accept that, particularly if you've got a judge with a big workload. But there's often, for example, our court, if you can't deal with the matter, it'll go to another judge. Expertise, that's always an issue. And that brings into play the referral out of part of a hearing to an arbitrator or to a referee. Cost. What would you say about cost? I think you'd be surprised. For $20,000 dispute, $100,000 dispute, absolutely. For $100 million dispute, I think that cost in arbitration is a real problem, or can be. I remember speaking to one very well-known fellow of the Chartered Institute out of the UK that said that the parties had a cheap and nasty arbitration when they were paid 3 arbitrators £1 million each. You know, I thought, well, really? Okay. So you got to be careful about that. So there's got to be a point of difference. If you're going to pursue arbitration per se and not through an adjunct to a court process, there's got to be a point of difference, and that's going to vary with each case. That in turn will vary with each contract, which is why so much time has got to be put into the dispute resolution clause to match the contract and what you're trying to achieve, rather than chuck in something at the end.
What's the panel's view then on dispute resolution clauses that are quite prescriptive in terms of process, as distinct from those that are quite loose and leave it to the arbitrator to respond to the circumstances as they find them?
I think this comes back to the point about familiarity. If you're an experienced arbitration practitioner, you're probably relatively comfortable with ad hoc arbitration and negotiating procedural orders and directions with an arbitrator. That's something that you just in your toolbox. If you're not, then having a heavily administered arbitration, I suppose, has the comfort of you've got the set of rules, you're putting everything through the institution, and they sort it all out.
Well, there's the administered, but I'm also thinking about sometimes I see DR clauses that go for a page that effectively seem to have second-guessed everything the arbitrator is going to do.
Well, you really need to.
I've seen them go for 5 pages.
Okay, 5 pages.
But are they those cascading? Sorry, you mean
Not just
negotiation, mediation,
but not just that, even just sort of,
right?
you shall do this and you shall do that.
And within so many days do this and so many days do that. Yeah.
Well, I mean, there's a balance. A court won't interfere in the interlocutory decisions of an arbitrator. So there's a balance to be found in the dispute resolution clauses about whether you're too prescriptive or you're not prescriptive enough. If you're too prescriptive, well, then you're going to end up with consequences you may not want. If you're not prescriptive enough, you're going to end up with a fine that may well delay the arbitration for some time. So it's a question of education on clauses, basically.
Yeah, I agree.
In my experience, I don't mind a bit more prescription when it comes to arbitration clauses, because I think what happens is that it stops the parties engaging in a dispute about those matters. There are certain things which have to be very clear up front. You have to have a very clear arbitration agreement with, I think it's best to specify, what your rules will be and where your seat will be, all of these things which sort of seem nonsensical, but I think if you've got it all there in your contract, then you pick it up and you go. And I think you don't get bogged down at the start with trying to decide these things. But you have to be, but at the same time, you have to be very careful about what you actually agree. I mean, I've seen dispute resolution clauses which say that the parties will spend 28 days trying to agree an arbitrator, and if they can't agree thereafter, an arbitrator will be appointed by the principal. Now, great if you're the principal, but if you're not, then you wait 28 days until the principal says, "Oh, we can't agree. This is who we're going to appoint." So but you have to be. I like a bit of rigor around the thinking at the start. So
Well, that comes back to just simply accepting what's served up to you.
correct.
That I'm talking to you personally.
Yeah.
And it comes back to the point that drafters don't spend enough time challenging the other party's version of the dispute resolution clause. I mean, it's a specialised skill, and that's where some of the problems arise. I mean, so in your case, contractor says, "What do you mean the principal is going to appoint the arbitrator?" So.
I mean, I'm meant to be facilitating, but from my perspective, I always have difficulty with the fact that arbitration is trust the arbitrator, and trust the arbitrator as the three most important principles. And you want arbitration, but then you don't trust the arbitrator by prescribing what they can do. Is that a failing of rules or a failing of education?
Good question. Probably a bit of both. I tend to favour light arbitration clauses. That's just the way I roll. Ad hoc light arbitration. Simply nominate the seat and let the Commercial Arbitration Act do most of the work.
You can adopt some rules, and the
You can
rules,
adopt some rules. You can
rules have
adopt
most of that
some
machinery
rules
you talked about in terms of appointment. If you
Yeah.
if you have a gap in appointment
Yeah.
or a challenge process.
Yeah. So yeah, you can. There's different ways. As I say, I think it comes down to the confidence of the practitioner. Who's, if you're confident of being able to manage a dispute in a particular way, that's the most important thing. I think is to get that reference to arbitration in there, and having done that, the arbitrator can do a lot of the work. Governed by, obviously, supervised by the court and the provisions of the Commercial Arbitration Act or the International Arbitration Act. I mean, one of the things we haven't even talked about, again, for the benefit of the younger practitioners, one of the advantages of arbitration is just the enforceability, particularly overseas. So if you're dealing with a contract that involves parties one party in Australia, one party overseas, it's almost a no-brainer that you're going to have an arbitration clause in that sort of contract, because arbitration awards are much more readily enforceable in other jurisdictions than judgments of the courts are. Some of the courts
We haven't really touched on the New York Convention at much tonight.
No. How long?
But on the New York Convention, and for those that don't know it, that's the mechanism by which international arbitration is able to be a process that is consistent around the world and enforced around the world through a very successful international treaty and an example of very successful globalisation. So perhaps now looking back, not looking back quite so much, but looking forward, do we see that that's going to have the same level of success in the coming decades, perhaps, than we've had at the moment?
Well, I was just going to say, I mean, if you look at how polarised the world is now, look at the New York Convention, and it's a miracle. It's a miracle that it was ever signed by the number of countries that are. Because if you tried to do something like that now, good luck. It wouldn't get off the ground. So it's a relic of another age, a very fortunate relic, I think, of another age. Do you think that? Is it fit for purpose in the 21st century? That's an interesting question. One of the issues that comes up is this issue around the form of the award. Electronic awards. It's signed e-signatures on electronic awards. Do they satisfy the New York Convention? Would anyone dare to reopen the New York Convention to try and amend it to sort of bring it up to sort of 21st century standard? I think not. I think it'll stay as it is, because for the reason I gave before, I don't think you're not going to get consensus
at an international level on anything in the foreseeable future.
And on topics like that, you can have inconsistent domestic legislation.
You can, unfortunately.
You have to be conscious of
Yeah.
sort of as an arbitral practice, the requirement that's going to be applicable to the most as far as possible.
100%.
But is there something that we should be doing in Australia in terms of either our approach or our legislative framework in terms of making sure that we do remain fit for the coming changes?
I don't think so. I think that the courts are pretty, speaking from a judicial point of view, the courts are pretty familiar with the New York Convention. It's not uncommon to have foreign awards registered here.
No, very common.
And I think it's a question of it ain't broke, don't fix it. And if it does need to be fixed, well, that's up to the High Court. Or the
Parliament, depending on what the fix is.
I guess the only question I'd ask, and I'd actually ask it to the room, do you think appeals on questions of law should come back into the legislation?
I might actually get the mic because I'm conscious, as I say, we're meant to be recording this, and if we're going to ask questions of the room, I want to make sure they get picked up. All right.
You know where it is, Andrew?
Yeah, it's just here.
He's done this before. Views? What do you think?
Right. Does anyone have a
We're working, yes. My view is yes and no.
Speaking like a true lawyer.
So in a contract that I was recently giving some advice on, the parties agreed to give their pre-consent to appeals on questions of law. I think if dispute clauses are going to be properly considered and properly negotiated between the parties, that's an issue that they can consider and deal with for themselves rather than making it a blanket rule.
Well, there is currently an opt-in, and it was that what they were doing, and they were opting into.
Yeah, they're opting in advance.
Everyone
else that wants
pretty
to
much happy with that, or is it?
Audrey, can you first?
I would suggest yes, just on the basis that, as Justice O'Sullivan raised, that is one of the hurdles to getting people to agree to arbitration is, well, what if they muck up the law and we don't have a remedy? So my encouragement would be yes.
That you might actually encourage more arbitration by having that right of appeal.
Yes.
And the opt-in right in the Act, in the Domestic Act, is not enough?
I think it's not enough.
And
So more UK style. You'd go more the UK Arbitration Act.
and for those, is that similar to the old Commercial Arbitration Act?
Yeah, there's a right. I think you need to leave that. Don't you? You need to
The
leave
old
that,
Act was you had to have a
Yeah.
manifest error of law on the face of the award and an issue of significant commercial significance. And if you passed those two hurdles, leave would be granted.
Yeah. Section, who's full bottle on the UK Arbitration Act,
Ah.
section 67, 68, one's manifest, one's jurisdictional and one's error of law, I think.
That means, so we're going back to the future. You go back to
Well,
the old.
Well, it's only really this issue about, well, would there actually be more arbitration? Is the fact that it's hard to appeal or you can't appeal, is that putting people off arbitration? And
I think to some it's people want finality, but not at the expense of getting a fair and a just result. And that's the issue. You're balancing those two tensions. So when you've got parties that say, okay, we do want a result which is expeditious, cost effective, and flexible, and we want finality, but we don't want to get finality and to not get an outcome which we can live with. And it's that safety net which I think the parties want, which is to be able to say, okay, well, the arbitrator really made a mess of this. Well, we'd like someone to have another look. But parties will live with it if it's a little bit, if they don't get everything they want and it's not quite what they expected, but it's a result that's reasonably just.
Could have gone either way, but
Exactly. But and that's I think that's a common human instinct.
I wasn't expecting to have an answer that we should go back to the past.
Well,
That's what I'm hearing.
Well, I think it was. I think they looked at that in Singapore as well, and I think they've decided to keep it as it is.
Can I just add a contrary view and picking up a point Marty's made about the importance of confidentiality, and as if there were an automatic right or a fairly open right to appeal, then you do potentially lose the real benefits of having a confidential process. And Marty's mentioned the NRA case, which was, I saw one of the huge advantages of arbitration in that was it was confidential. But as soon as it appeared in the courts and it's in the newspapers and albeit a side aspect, but so I think you have appeals, it becomes public, and then that advantage is potentially lost. So I think sort of again having a process where it's the parties agree up front or agree amongst themselves whether or not they'll have appeals to the courts has a real attraction.
But don't put that in the legislation.
But does that mean the courts need to think about how they publish those decisions as well?
As in anonymised?
Yes.
Yeah. Well, they can.
I mean,
that's an option.
It's like it's not at all uncommon to get applications for confidentiality orders because of commercial sensitivity. The success or otherwise of obtaining an order depends, of course, on the particular circumstances. Some it's a no-brainer, others it goes the other way. No. That's not confidential.
Well, those that are familiar with what they do in Singapore will have noticed that there's, a lot. Doug Jones says every arbitration award in Singapore is challenged. That's probably a slight overstatement, but they anonymise them with ABC versus XYZ. So the judgment is published, but they just they speak of Ruritania and ABC XYZ to mask the details.
I'm not sure that would always maintain confidentiality, though.
No, probably not.
A $1 billion hospital would be in Adelaide, South Australia.
Well, I could say Ruritania. There's $1 billion hospital in Ruritania.
Under the South Australian Commercial Arbitration Act.
But it is interesting, and whether or not there can be some sort of hybrid approach where an appeal goes to the court and then is referred back out and is confidential. I mean, maybe we need to have some more critical thinking about how we can achieve that.
Sorry.
Oh no, I don't think there's any limits about it. I think that a discussion between bodies like the Institute and the judiciary about some of those issues will always be well received. My impression is that at least at my court, they're not closed minds, and there's some very experienced minds. And if an approach was made to the Chief Justice, for example, about a particular problem, then Her Honour would be either deal with it or send it out to someone who's got experience in the area to deal with. I mean, we've got all the national practice areas, so coordinating judges. There'll be a report prepared.
My experience is it's not the judiciary. The problem it's sometimes it's the practitioners that have a lack of confidence or familiarity, and when you get parties on either side that embrace a process and can see the benefits to an alternate process, generally that's when you get the outcomes.
Yeah.
But the manner and speed with which we responded to the Parliament decision in terms of not having confidentiality as part of our arbitral jurisprudence, which put us out of step, and had then amended both at a state and federal level the legislation to bring back the confidentiality. Does that suggest confidentiality is a more important feature than we realised for a lot of parties?
It is one of the key drivers I see. I see that from the parties that I deal with, and that's one of the key attractions for arbitration. Not sure that it's always beneficial though. Like I do see sometimes that we're in really large, hard-fought arbitrations, because of the need for the arbitrator to afford procedural fairness. I sometimes think that confidentiality can be a detriment, right? Because sometimes the arbitrator does bend over backwards to make sure that the parties are all afforded natural justice in arguing every point and making every application, whereas I think sometimes the judiciary would probably shut it down and move on. But I have to say, confidentiality is a key driver.
Well, it is. I don't think there's any doubt about that. But it's also an easy driver, in the sense, if you say to any business, look, the advantage of arbitration is confidential, what do you think? That's the way you know my business necessarily, out in the public. But it's got to be balanced against the other pros and cons.
Yeah.
So what you're referring to there a moment ago, Marty, in terms of the bending over backwards, the sometimes called that due process paranoia. Those who might be familiar with that
expression. A few things.
An expression that sometimes is a concern about arbitrators. My perception was the appeals actually created more paranoia. Would we possibly be pushing against the stream if we liberalise the approach to appeals? Sorry, Judge.
No, that's right. I was talking about confidentiality and of course the award is confidential anyway, until such time as you want to register it, and it doesn't become confidential. And there are, that can be the subject of an application. Certainly, if I'm dealing with confidential matters or matters in which there's been confidentiality orders, I and also my colleagues will not publish our reasons, hand down a decision and provide a copy to the parties, but they're not published. And so if you've got problems with confidentiality in any of these reasons, come back to me, let me know, we'll have an argument about it if we need to, and then I'll publish the reasons, with the appropriate redactions. There'd be no reason why that couldn't happen on an appeal. The court would have to see the unredacted version, of course, but in its judgment, an application could always be made for confidentiality. Sorry.
Would it assist the process if that was the default position?
It'd never be the default position because of the open courts policy, the open justice policy. That wouldn't fly. It would have to be on a case by case basis, and it would have to be fairly strong reasons. I mean, there's lots of judicial statements to the effect of, well, look, if you're going to come to the court and it's a commercial dispute, expect your commercial laundry to be aired, and there's some force in that.
But I suppose the countervailing point is one of those parties at least didn't want to go to the courts. They wanted to go to arbitration and didn't think they were going to get their commercial laundry aired. And now the other party has taken that out of their hands.
Yeah, that's true. That's just the way it is. There's not much you can do about that.
Is there any other comments from the floor?
Look, just the due process paranoia point. Look, you asked me at the beginning what the relevance of Ciarb. And as I say, I'd like to think that our arbitrators and fellows are well trained and are going to be in the Ciarb way of doing things, and hopefully less susceptible to due process paranoia. But you can't, that's a very individual.
Is it a real thing?
I'm sure it is.
For some arbitrators?
Yeah. Look, I haven't come across it. I don't come across it very often. And I've described it as, a form of Darwinism. If people can't make a decision, you won't appoint them again. That's really the only way that you can. I think there is a process under the Ciarb Code of Conduct to raise complaints through Ciarb about the conduct of an arbitrator if you thought they took too long or cost too much or whatever. So there is that process that you wouldn't necessarily appeal it, but you could lodge a complaint about the conduct of a particular arbitrator. But you know, it affects judges. It's not just an arbitrator thing. It's just individuals in a particular case can get spooked by, bullied by advocates or something. I don't know
All
what
parties
the
think their
causes
case
are.
is simple and straightforward and they should win instantly. So a lot of my clients, I think, feel that things are taking too long because they don't understand the process that they need to go through. And so that's why I ask, is it a real thing?
Well, I was at a talk that James also gave, and he described the process of being as a trial judge. Your principal job is to get it out, he said. And as an appeal judge, your principal job is to get it right. And he says, as an arbitrator, you've got to do both. And that might be part of where that could be part of the problem.
Could I just raise a point about that?
Sorry, just
One of the
Is that on?
one of the issues I've seen of recent times is arguments about admissibility of claims or jurisdiction, and that really ties in with the point I think Marty was making before about the dispute resolution clauses, particularly in these construction contracts. If they're too prescriptive, the risk is that parties aren't actually going to follow the steps that need to be followed. And what that will mean is it'll lead to an argument about admissibility or jurisdiction. And so it seems to me that one of the distinct advantages that a court does have is it has its inherent jurisdiction. Whereas in arbitration, you're always going to be confronted, if you've got someone on the other side who wants to play every club in the bag, you're always going to be facing an argument about, well, that entire claim, even though it may be a counterclaim and a set-off, hasn't gone through the dispute resolution procedure and therefore is not admissible before the arbitrators. Now, it seems to me that that could actually be an easy fix, because that might be a statutory thing. If you were to, there's a section of the Act already which deals with admissibility at jurisdiction and the competence rule, but there's nothing that clothes the tribunal with an inherent type jurisdiction. Now, that might be a bridge too far, but I mean, the federal court, for example, is a creature of statute and has inherent jurisdiction arising from its founding statute. So it seems to me you could slip in a clause, a section somewhere that says not only can you determine whether or not there's an arbitration agreement, but any claim that arises naturally out of a claim that a counterclaim or defence, particularly a counterclaim, doesn't need to go through the process in order for it to be before the tribunal. I don't know. It's just something I've noticed in one particular case where they're raising everything they possibly can, and admissibility or jurisdiction is something that scares arbitrators, and understandably so.
I think we can push back on that. But that comes down to the framing of the notice of dispute. There's a little bit of flexibility with it, as you know, but there's not a huge amount as to whether or not something has been properly referred.
Whereas the court doesn't have that.
No, just refers it out. Just either deals with it or refers it out to arbitration. Well, sorry, it's constrained. Well, broadly constrained by the pleadings, but yeah.
Just on next point, I was just going to add, my experience has been where I've had cases where we've ended up with 3 or 4 arbitrations under the umbrella of the one arbitration to deal with that point, because people are taking jurisdictional points, and then you think, well, if they're right on that, I need a new arbitration, so you whack in another notice and another arbitration.
But there's even a worse complication in that some of these construction contracts have technical disputes and commercial disputes. And so a technical dispute must go to well, basically an engineer to resolve, whereas a commercial one must go to a 3-panel arbitrary tribunal. The problem is there's a significant crossover between technical disputes and commercial disputes, because take, for example, defects, which is holding up completion of the project. There might be a technical dispute about whether it is a defect, but the consequences of it are liquidated damages or et cetera, et cetera. So it gets messy. And if you know, that sort of area is ripe for jurisdictional challenges. So fix a jurisdiction and there's no challenges. Not going to happen, though. I accept that.
Slip it in a statute.
Yeah. And that's the other thing. And if you want to get something shut down by the High Court, try and make it into a court with its own inherent jurisdiction and see how that goes.
Sounds a bit
And how
Trumpian.
would that work under the New York Convention when you try to enforce the arbitral award overseas?
You wouldn't. You wouldn't.
I think I'm trying to work out which one would be easier. I can't work out which would be easier, amending the New York Convention and getting 159 countries to sign, or is it more than that now?
159 feels about right.
Yeah. Or getting an arbitral, or getting the legislature to give some inherent jurisdiction to arbitrators. Just wait to see which of those happens first.
Or make sure your clause is properly drafted.
Yeah. Yep. Or for notice of dispute.
There was a great case that exercised my mind, which was a decision in trying to quickly remember the facts. There was a dispute over a charter party contract in the UK, and the respondent appeared in the arbitration. So the claimant, the arbitrator said, yes, there was a charter party, and yes, it contained an arbitration agreement, and I find that there was a breach, and I'll publish an award in favour of the charterer. And when the charterer tried to enforce the award, no, I don't think that the ship owner then applied to the court to set aside the award on the basis that there was no contract. So that it's one of those great shipping cases where there'd been an exchange of telexes or something, but that there was an issue about whether a final and binding agreement had been reached. And so the court then said, well, notwithstanding the fact that the arbitrator made a decision that there was a contract and it contained an arbitration agreement, we're going to decide, or I'm going to decide, that in fact there was no contract, so there was no arbitration agreement, and set the whole thing aside. Which is just one of those, those great paradoxes, I suppose. You say to arbitrators, well, you've got jurisdiction to determine your own jurisdiction.
Yeah.
Actually, you don't.
Yeah. Well, I think that's now finished. That problem's fixed in the Act, because it used to be that if you were going to argue, if you're going to seek to have it overturned at the end of it, you just wouldn't turn up to the arbitration. Yeah. And when they tried to enforce it, you'd run an application like that now. I think now the Act, the International Act and the Domestic Act says you must raise it by this time, otherwise you're out of court.
I think you've got 40 days to, after the tribunal makes a jurisdictional decision, you've got 40 days in which to challenge it.
Yeah.
I can't remember why that didn't happen in the UK.
Yeah. I know there's one of the TV stations in Singapore or something also had a massive fight like that, but I can't remember the name of it. I learned it when I did my excellent international arbitration course through the Chartered Institute.
I should give a plug for our courses then, shouldn't I? Is that going on?
Is there any other questions from the floor for the moment on that topic? No. Well, not on that topic of training, but one of the things that came up during the COVID pandemic and a lot of discussions at arbitration was, how does arbitration deal with things like remote hearings? More recently, a lot of courts have struggled with how does a court deal with things like artificial intelligence. One thing that's not going to change is ongoing technology. What role is there for practitioners, the Chartered Institute and the courts in assisting the arbitral process to continue to be able to respond and deal with these changes in technology?
Well, Ciarb has guidelines, published guidelines in relation to the use of AI in arbitration. So I'd encourage you all to have a look at those.
I've anticipated the AI question. I'm here.
Well, I should just hand over to you, Marty. That's really what I was going to say. And I suppose it highlights transparency about the use of AI in the process. And I think so long as everybody knows what is being done and whether, to the extent to which AI is being used in the process, then there can be no scope for complaint after the event. But
I've had a look at these today, and I hadn't previously had a look at them, and I think that they are excellent, and I would highly recommend them to everyone to pull and have a look. There's even a draft
procedural order,
in the back, which
long
is
form and short form,
which is excellent, which is really comprehensive. The only thing that I would add was that we are in a state of flux now where each court is grappling to deal with how they're going to treat AI. And I think the federal court came out and published a release which said something to the effect that we're working it out, but in the interim, please be transparent and tell us if you're using AI. I'm paraphrasing, but it was to that effect, I think. Yeah. And then there was also recently there was a statement from the New South Wales Law Society and the Western Australian body and the Victorian body on the use of artificial intelligence, which came out. And it was interesting when I had a look at it. There were some differences, and in the sense that the Ciarb one sort of said, AI can be really helpful for translating text, and the joint body one came out and said AI should be prohibited when it's translating text because it needs to be verified, right? So I think that one of the things that the peak body needs to do for arbitration is perhaps be cognizant of drawing together the various, which is a challenge in itself, and making sure there's consistency for arbitration. But beyond that, I also think that from my perspective, that where we're in a real state of flux, the risk of harm for AI is really unknown. And I think that's where the Ciarb, as that peak body again, can actually gather information from all of the stakeholders as to what is the effect of using AI, because we don't really know, right? So as we're starting to use it, I've seen AI used successfully in a number of places in different areas. For example, I sit on a government procurement committee where there's all of these applications, and someone's developed a program for use which just actually analyses and confirms that all of the guidelines have been met. It's a very regulatory type thing. But I think that here, where particularly if arbitrators are using AI, there's potential pitfalls from that in terms of replacing decision making. And there's a real need, I think, potentially long form for law reform if around AI. And so I think on that sort of watching brief, I think that's where it's really important for the Chartered Institute to really keep a watch on that and see how these guidelines are implemented in practice, and what further law reform needs to be made to the Commercial Arbitration Act or in other areas to protect against I think really generative AI and the problems which can be caused through the bias which will arise from that training. Because I think that's where the risk really is that and we see it in algorithms sort of, on your Instagram page, it becomes an echo chamber. And if I mean, sometimes, I really do fear looking certain things up because I don't want to be spammed with that information. It's the same here. If you're feeding a whole lot of biased information in, AI will learn in that way, and so that's the real risk.
Yeah, well, I think that's right, Marty. I mean, you're right. The federal courts, we're just sitting back and watching for the moment. New South Wales Supreme Court went out early,
And hard.
and I've seen affidavits filed in our court by New South Wales practitioners that say this affidavit has not been prepared using AI, which I assume is a practice direction from the court. But ultimately, I think a great deal of caution is warranted. The experiences thus far have shown up some real problems. Hallucinations is one, and we've got to be very careful. So, particularly with self-represented litigants, they'll put up a case, Smith and Jones, and you write in the judgment, Smith and Jones. I can't find any record of it. Next thing you know, O'Sullivan's quoting Smith and Jones. In a judgment. And I mean, I had a self-represented litigant before me not long ago on a leave to appeal. And I was going in about 20 grounds, of course. I was going through them saying, well, I'm not sure I understand this first ground. What do you mean by it? And she happened to say, well, I'm not sure. That's helpful. But I've had it analysed. I said, all right. Did you use AI to do this document? Yes. So it didn't understand what was being put. And Bernard Murphy, one of my colleagues in Melbourne, you might remember, ordered indemnity costs against payable personally by a solicitor in circumstances where they hadn't checked the AI. It was misleading. So it's one of those problems where you've got to be very careful about how you use it and how you accept it. And I think it's going to be an incremental thing. I'm not an AI naysayer, far from it, but I treat it with a great deal of caution. I think the short answer is if you're going to use it, make sure it's right.
I've seen it. I can't remember what the program's called. It's called Legal Equip or something. Or there's a program where you can feed all the information in, and it is actually really good at, and the real benefit is to the AI can summarize and pick up issues, and it was a case which one party was saying that they didn't have any financial involvement in certain businesses, etc., and the bank records suggested otherwise with a whole lot of stuff. And what the results spat out were great. It was like, here's further action we suggest, and blah blah blah, and what's being said is not consistent with this, and it was good, but it was so dependent on the information that was being put in. And when I went to have a look at some of the underlying documents, I was like, well, for example, that's well and good that you've got a current asset statement because it's saying, they're not a beneficial owner, blah blah blah. I'm like, but where's the historical statement? The AI can't tell you that sort of thing. You're just saying, well, was this party ever a director or shareholder? They weren't at that point in time, but they might have been previously. And that's where you're so reliant on the information which is being fed in. There's no judgment or analysis. But there are some programs out there now where the AI will actually tell you questions to ask in cross-examination. Have you thought about asking this? And it's absolutely boring.
Are they good questions?
Sometimes, but I mean, not always, but yeah. What concerns me is the speed at which people are now using AI. But without any checks or balances.
Well, the danger is, frankly, laziness.
Yeah. I don't know how to use it, and I wouldn't rely on it. But I've seen other people use. I've seen the results, and I'm like, wow, it's actually take me longer to learn how to use it properly, I think, than to actually just do the work. But there'll come a time where you will have to, because it's you'll be competing against other people who have used the programs. So But no, I think it's just the risk of harm and actually watching what the negative effects are. We can publish all the guidelines, but it's what the actual user experience is, which is going to have to be monitored moving forward. Anyway, that's my view.
I was going to do questions at the end, but I'll do questions at the end. Is there any comments from the floor in relation to those matters?
Just a comment on AI, so maybe off topic for arbitration, but I've just had a few goes recently at trying to use some of the paid programs from people like CCH and Lexis. The danger of AI in those programs is it gives you answers which are in absolute terms, and you can use the two different programs and get two different answers. So one question today, I was trying to work out what a lump sum compensation figure was under the Return to Work Act, and the two programs gave two answers which were out by a factor of about 10, and so there's either a right answer or a wrong answer on that question, but the way it's presented is to the practitioner, this is the answer and here's the reference, and if the person doesn't check that, the danger is that you just use that shortcut. And another example is when it cites cases, the cases often don't stand for the proposition, and that's on the paid thing. And if you use ChatGPT, it'll come up with a case which either doesn't exist or it's a reference to a criminal case, not a civil case. So there's just massive dangers on using it for research.
I've also seen people using a bit recently for meeting minutes, and so you'll have a meeting and the AI will monitor the meeting and then it'll give you the summary of the actions at the end. And you can actually see from the actions it gives you the inaccuracies of it, just in terms of, someone sent one to me a couple of days ago and I was like, well, I'm not doing that and I'm not doing it, so, but, it's okay to a point, but, you're right. It's the verification process which is needed. If you just adopt it and move forward, that's where the errors will arise.
Justice Futrell, in a seminar that we ran earlier this year about AI, made the observation, which I think is one that I've always thought is, isn't it a bit like getting a young lawyer or a trainee to do some research for you? And then you don't get that memo and hand it up to the judge. And if you do, and it's wrong, it's your problem, not the assistant. You're putting your signature on it and you're tendering it. It's whether it's been produced by a young lawyer or an AI.
Yeah, I mean, there's something in that. It wouldn't be the first time I've had a case cited to me that doesn't sound for the proposition it's contending for.
Yeah, whether it comes out of grok or whether it comes out of
but that's what I said. It's got to be, you've got to be careful.
Bringing it back to arbitration, the importance for arbitration is that we have bodies like the Chartered Institute that produces learned papers that give guidance to arbitrators, practitioners in terms of how to use AI.
Yeah, for sure.
See, that's a really interesting point, isn't it? That you go to an arbitrator who uses AI, it's wrong, and there's no right of appeal. That's the perfect storm, isn't it?
Well, no, I think you'd probably have grounds to challenge. You'd have recourse well, the proceeding wasn't conducted in accordance with the process agreed by the parties.
If you knew the arbitrator used AI.
If the party, well, I don't never say never.
Sure.
I think it's more an issue of the way the parties present their cases and the evidence that they present, which is of concern in the Ciarb guidelines.
Rather than the arbitral award.
Rather than the arbitrator, him or herself, or the tribunal itself, using an AI tool to assist them in the synthesis of that evidence and the production of an award. I think you'd have to have very clear consent of the parties to say, is it okay if I run your submissions through an AI tool that will produce a case summary or a chronology or a statement of the facts. And on the basis of that, I will write my award. I don't think many people would agree to that.
No, but you'd have to have I think you'd probably have to have a specific provision that says, unless the parties consent, the arbitrator will not use AI. Or you put it the other way.
Well, that's a good question. I don't know. What do
Well,
the
I think
guidelines say,
the
mate?
guidelines basically say, excuse me, that, I mean, one of the
There
main,
is a section there, use of
yeah,
AI
one of the
arbitration.
main issues is about arbitrators not relinquishing their decision making
Mm.
to AI. I think that's the real concern here. Sorry, excuse me.
It's got to be the arbitrator. Yeah, sure.
Is that you don't just put everything in and say, tell me who wins. You know?
Bear in mind too that a lot of these AI tools are putting out into the ether all of the information that you're putting into it. And I'm speaking now with my IP hat on, and we're talking about confidentiality of arbitrations and court matters, with the exception of some very specific closed loop tools. The most of the AI tools are learning from what you are inputting and are spewing that out to some other user, possibly with your client's name on it and your client's confidential information in it. And at Piper Alderman, we have banned all AI tools with the exception of one, which is one for internal meetings, which allow you to record the internal meeting and look at the outcomes, which just saves the minute taker, but you wouldn't put client information through it. So there's still a long way to go, I think, before we could accept it.
Interesting in terms of what we've discussed today in relation to arbitrators. You know, one of the guidelines is that the arbitrator may consider using AI tools in the context of their mandate. Query whether or not the parties would agree to that. But the other three are not to relinquish the decision making to AI. That they should independently verify, which we've talked about today. And then the last one is the arbitrator shall assume responsibility for all aspects of the award, which is that you wouldn't hand up the clerk's homework as your own, right? So, you know, I think we're perhaps spot on the money of where the guidelines are thinking.
But to his honest point, I suppose, does the arbitrator then need to put on a footnote on the award saying AI was not used in the production of this award? Because otherwise, how would you know?
That's right.
Yeah.
Maybe.
One area of concern is with experts, and you can sort of understand why there would be a paranoia about experts using AI, because how would you know? I mean, how would you know that the opinion that's being expressed is not the computer's opinion? So that, I think, is something that's going to be brought into sharper focus pretty quickly, I would have thought. I mean, heaven help us if we're paying experts to get ChatGPT to draft something.
But then again, a little bit like we're talking about with the handing up the clerk's research, for as long as I've been in practice, you'll have forensic accountants who get a room full of people to crunch the data and the documents and do the analysis and prepare the models. And then a partner will put his signature on it and say, yep, this is, here's my report.
I suppose that is, it's the same thing. It's the back office doing the work, and that could often get exposed.
So the partner obviously has to make sure he or she has to be very confident that the number crunching has been done properly.
Yeah.
Because he or she is putting their signature on it, but it comes back to the verification point.
Yeah.
Got to verify it.
But normally, an expert would disclose that I've been assisted by so and so and so and so. And I think a judge would look rather dimly if it was exposed in cross-examination that it wasn't actually purely their own work. I mean, I'm thinking of quantity surveyors. It happens all the time that they've got someone's done one part of it, someone who's a specialist in bricks or has done that part of it, and another guy's done that part of it.
One assumes.
Sorry, I meant it in that sense.
One assumes though that if an expert is
putting their signature on a report and they are going to get cross-examined on it.
Yeah.
And they're asked a question, can I take you to page 723 and this calculation here?
Yeah.
And the expert says, oh, sorry, I didn't do
I
that.
didn't do it. Yeah.
Well, except you know, the admissibility of an expert report is on the basis of expert opinion.
Yeah. Yeah.
Expert opinion is that expert's opinion based on the material in the report. It's not AI's opinion. So there's, you know, a point that will probably arise. Well, whose opinion is it? Is this your own work?
But then, of course, if you, yeah, it's the risk is that if it's on a topic that requires, unlike say forensic accounting, quantity surveying, which might be checkable if you could go through the effort of doing it, some science like DNA, etc., is beyond the reach of most people, I would have thought, to try and go behind it. So that's the risk, is when
engineering, you know,
yes.
where they do the calculations, but they give an opinion as to whether or not a footing is sufficient to withstand the forces imposed by the subsoil conditions.
And to try and read their calculations too is impossible.
Adam, I think it's the last question over here, and then we might need to wrap it up.
Continuing on the AI theme just for one moment, it sounds though the concerns that everyone's raising are the same concerns effectively as a clerk producing a first draft and it not being checked, as a tribunal secretary doing more than the tribunal secretary's role, as an expert's offsider doing more than the expert's offsider role. Those are perennial problems. We've just got the same issue. But AI is not limited in theory to being the offsider. To use an example, which I might be stretching my knowledge a little bit, but I recall that in the science of protein folding, the AI tools specifically are the things that have led to the massive quantum leap in advance. And there are no humans who can do that work. They rely entirely on the computer AI system to do it. They know that it's right because they can go back and check it later, but there's no humans who can actually do that work. So that's, if there's a concern, isn't that where it's that type of thing that should be the concern?
I'm not sure I'd see where the concern is.
Are you suggesting whether to appoint an AI as the arbitrator?
You might get to a point where there are questions to be determined in arbitration that no human can determine without relying on an AI's opinion.
Within a reasonable time.
Within a reasonable time, or maybe at all.
Yeah, that's a whole interesting topic. I mean, I would struggle then to see why there's a dispute. I don't want to get too bogged down in this, but if no human can work out what the answer is, how can there be a dispute about it? But anyway,
That may be a nice point.
I understand you. I understand.
Esoteric point for us to wrap up the evening. I'm conscious of the time. Look, I just wanted to thank our panelists very much for their time and their very engaging comments that we've had. I've learned a lot. It's been very interesting, and I want to thank you all again, and perhaps just ask you to all thank them again.
Thank you also for being so engaged.
Also, thank you also for the attendees and for the questions. There is still plenty of food and drink, and there's hopefully some of you will have time to be able to stand around and continue this conversation down the back. But otherwise, thank you all once again for coming, and hope to see you at another Chartered Institute event. Thank you.
Thank you again. Thank you.